In Florida, thousands of tenants get evicted every month because they never saw a critical notice that was stuck to their door or lost in the mail. Right now, under Florida's ancient laws, landlords can kick you out of your home based on a piece of paper they claim they taped to your door, even if you never actually saw it. It doesn't matter if you were traveling, it rained and destroyed the notice, or someone else took it down. You're the one who ends up homeless. And the landlords, they're losing millions in court battles over whether notices were properly delivered. But all of that is about to change dramatically. Florida just passed House Bill 615, a revolutionary new law that could save your home, your deposit, or your rental property by finally allowing landlords and tenants to communicate by email. Welcome to the 21st century. In this video, I'm breaking down exactly how this game-changing law works and why missing this update could cost you a lot. After watching, you'll know exactly how to protect yourself with these new electronic notice rules, and I'll also share the form you need in order to opt into email communication with your landlord or tenant. My name is Bashoy Habib, and I'm the realest real estate attorney you know. Over the past 13 years, I've closed over 1,000 transactions totaling $12 billion. I've seen countless landlord-tenant disputes that could have completely been avoided with proper documentation and communication. This new Florida law directly addresses one of the biggest problems I see in my practice every single week. Let's talk about why the current system is broken. Right now in Florida, most important rental notices must be delivered in person, by mail, or in some cases posted on your door. This outdated system was designed for a world before smartphones and emails, and it fails constantly. Think about your own habits. How often do you even check your mailbox? I can tell you personally, unless I'm expecting a check or a package, I could go days or even more than a week without checking my mailbox. It's not that I'm lazy, it's just that there are very few important items that come through the mail, so I've been conditioned to not care. My email, on the other hand, I might literally check this thing 100 times a day. We live on our phones now, but that's just the reality. But until this new law, Florida tenant relationships with landlords was stuck back in the 80s in terms of communication with landlords and tenants. I've seen tenants miss eviction notices because they were traveling. I've seen landlords unable to prove that they sent maintenance notifications. I've seen security deposit disputes drag on for months because of mail delays. And all of this leads to costly court battles that no one wants. It's just inefficient all around. Not only that, it creates unnecessary conflict between landlords and tenants who are often both acting in good faith. So what exactly has changed? Governor Ron DeSantis just signed House Bill 615 into law, and starting July 1st, landlords and tenants in Florida can legally send important notices by email. This new law modernizes the entire system to match how we actually communicate in 2025. But here's what makes it truly brilliant. It's completely optional. If you prefer the old system, you can keep using it. If you're elderly and you don't like email, that's fine. You don't have to do this. If you want the convenience of electronic notices, you now have that option. The law gives you flexibility while adding protections for both sides. Something important to note. This isn't just some administrative tweak. This is a fundamental change to Chapter 83 of Florida statutes, which is the law that governs the relationship between landlords and tenants in Florida. When the legislature makes changes this substantive, you need to pay attention. Here's a scenario I see all too often. Tenant rents a place and then moves out. Landlord makes a claim on the tenant's deposit. Landlord follows Florida law and sends tenant an itemized list by mail like they're supposed to do. The tenant never receives that mail because it was sent to a forwarding address that is no longer valid, even though it might have been valid at some point. Maybe the tenant didn't update it and it's no longer valid. Now, both parties have acted in good faith, but by the time the tenant realizes what happened, the window to contest the security deposit is technically closed, and so it becomes much more expensive and difficult to challenge as a tenant. But all that could have been avoided if the landlord could have just sent an email and that counted as notice. Tenant sees it, and within a day or two, they can kind of start negotiating or talking about that. Other areas this will be helpful is sending non-renewal notices and maintenance requests, which will be received immediately. And I'll talk about more case examples later on in the video. Both the landlord and the tenant must agree in writing to use emails for notices. And this is a very important point, right? So it can't be unilateral. I can't force the tenant to accept email, and the tenant can't force the landlord to accept email. The law actually specifies that the exact language that must be included in your addendum, and it spells it all out. But rather than bore you with the details, I've gone ahead and prepared a form that you can use for absolutely free to opt into the new email laws here in Florida. It contains all the statutory language. It is in compliance. All you have to do is follow the directions in the description below to get your free copy today. Now, under the new law, Notice by email is considered delivered as soon as it's sent, right? So that's when it's delivered, unless it gets kicked back. So if it says undelivered, the email address is wrong, obviously that doesn't count. But if I hit send and it goes through, that's the moment that your notice is considered delivered. So all the days start from that point on. And it establishes exactly when the legal notice occurs. And it's important to note, either party can revoke their consent to receive email notifications at any time by giving written notice to the other party. The notice is effective immediately, but it doesn't affect any email communications that had already happened. So you can't take back the right to email notifications and then reverse something that already happened. It would only be moving forward. So what kinds of notices are covered? Pretty much everything important in a landlord-tenant relationship. So for landlords, you can now send 3 days notices to pay rent or vacate, 7 days notices to cure violations, lease termination notices, rent increase notices, security deposit disposition statements, intent to enter the property, lease renewal offers. For tenants, you can send maintenance or repair requests, notice of intent to vacate, security deposit disputes, lease renewal decisions, requests for accommodations or modifications, notices about extended absences. Think about this from both sides. If you're a tenant, you'll know immediately if your rent is going up, giving you maximum time to plan. If you're a landlord, you'll have instant confirmation that your tenant received your 3-day notice to pay rent or vacate. This is especially valuable for time-sensitive information. Under Florida law, tenants have very specific timeframes to respond to certain notices, sometimes as short as 3 business days. Having electronic delivery can literally be the difference between keeping or losing your home. Now, I want to emphasize something important. Just because these notices can be sent electronically, it doesn't make them any less legally binding. An email notice to vacate carries exactly the same legal weight as a posted or a mailed notice, as long as you filled out that form that I'm going to give you and everybody's agreed to electronic notices. The courts will enforce these as electronic communications just as strictly as they would traditional ones. It's important to establish email communications with your landlord or tenant early on with simple and non-urgent emails. This establishes that the email is valid, opens the line of communication, and decreases the chance of the email going to spam or junk. That's just my opinion on this. Remember, even if it goes to your spam or junk, it's still considered delivered. So the onus is on you as the recipient to make sure you check that, and I'll talk about that in a second. You also want to make sure you update your email if it ever changes, if it ever gets hacked, anything like that. Otherwise, you're still legally responsible for notices sent to your old address. So another pro tip for you, if you like to use your work email address, which a lot of people do, I don't know why in this day and age people still do unless you own your business, but you could get fired or laid off or let go or move at any point. And so your work email might not be valid in a week or a month or a year. Why don't you just create a Gmail or a personal email account that you can carry with you forever for things like this? If you give your landlord your work email and you switch jobs and you just forget to tell the landlord, because why would you think to do that? And then they have a notice and they send it to your old email and it doesn't bounce back. It's considered delivered, even if you don't have access to it anymore. It's not on the landlord, it's on you. So make sure you have a personal email if you do, and if you don't, maybe you create one, because you have to have access to it at all times. So let me share some best practices that'll save you from headaches. For landlords, update your lease forms to now include the email notice addendum that I'm going to share with you. Always use read receipts, so there's an option that you can see when the person receives it. Try to click that. Just gives you a little peace of mind that they got it, didn't bounce back. Keep a separate folder in your email for each tenant, and you could probably put this in the client, the tenant files. Send a test email when first setting up electronic notices. Document when tenants acknowledge receiving your emails. Print and save important electronic communications, or at least PDF them and save them on the cloud. Consider using a dedicated property management email rather than your personal one, especially if you have several properties. And consult with an attorney to update your lease before July 1st, 2025, which is when this kicks in. I already have clients coming to me and we're modifying the lease to accommodate these changes to Florida Statute 83. And it's important that you do so as well, because that will strengthen your ability to rely on these email communications as a landlord. As a tenant, send a test email when first setting up electronic notices to make sure your landlord gets them. Always reply to confirm receipt of important notices. Update your landlord immediately if your email changes. Add your landlord's email to your contacts so it doesn't go into spam. Check your spam folder regularly, and keep a digital folder of all landlord communications. Like I said, whether that's a subfolder within your email, whether you PDF emails and throw them in the cloud or somewhere safe, but either way, keep a trail. This electronic notice law is just the beginning of Florida's modernization of landlord-tenant relationships, and it's about damn time. The legislature has been increasingly active on updating Chapter 83 over the past few years, and I expect that trend to continue. We're moving towards a more digital, transparent, and efficient rental market in Florida. This shift benefits responsible landlords and tenants alike by reducing paperwork, speeding up communication, and creating clearer documentation. Over the next few years, I expect we'll see additional changes regarding online rental applications, digital signatures on leases, virtual property inspections, and potentially even blockchain-based recording keeping for rental histories. The landlords and property managers who adapt the quickest will have a significant competitive advantage. The tenants who understand their rights under the lease and the new digital systems will be best protected. Remember, the law will always lag behind technology because that's just the way it works, but it's steadily catching up. This electronic notice law is a perfect example of legislation finally aligning with how people actually live and communicate in the modern world. To be honest, this could have been implemented 10 or 15 years ago and it would have been a great idea. This simple change to Florida law is going to save thousands of landlords and tenants from unnecessary disputes, miscommunications, and expensive legal battles. It's one of those rare legal updates that's a no-brainer and legitimately makes life better for everyone involved. It's also cool because it doesn't hurt anybody because you don't have to opt in if you don't want to, and then you're unaffected by it. So I just think it's a great idea. If you're renting or you own rental property in Florida, updating your lease agreements before July 1st is very important. If you found this video helpful, hit that subscribe button for more practical legal advice that actually protects you in the real world. And drop a comment if you have any questions about this law. I read them all, and I might feature your question in an upcoming video. Thanks for watching, and I'll see you in the next video.